Hello, welcome to our E3 webinar, Pathways to Permanent Residency. Let's give folks a few minutes to join, and then we'll get started. What we'll do is we'll make sure that at the beginning I'll just go over through some of the concepts, and then if you like, at the end we'll just have Q&A. And that way we can make sure that, I touch on all the subjects that you're looking for, and we're able to get all the information that you need to get you on your immigration journey. So I hope everyone's having a good Saturday. And, I am thrilled that you decided to join me today, this Saturday, for this really important presentation. And so we shall get started without any further ado. I think if anyone else is going to sign in, then we'll just, they'll have to join and wait to see. But please make sure that you put all your information on the Q&A, all the questions you have, and let's get started. So there are different ways you can connect with us. There's Facebook, Twitter, Instagram, YouTube, LinkedIn, Telegram, and we just truly like to connect with you folks. So we look forward to connecting you on many mediums. This is, we've got a YouTube channel, and there's a lot of really good information on that channel in terms of the PERM information or visa bulletin, or trying to figure out what the Child Protective Act is. That may be, something that you're interested in. And also, especially as this Biden administration starts rolling out all these new initiatives, what's going to be great is we'll be able to get the latest. Now, I am part of API 100, which is the 100 Asian Pacific Islanders that has been selected to kind of take part in facilitating policy for the Biden administration. So I'll have some inside tracks. So make sure you join us on our webinars to get the latest information. Today, the things we're going to talk about is we're going to cover green card pathways, E3 extensions, the whole issue of dual intent, concurrent employment, and other E3 portability and critical issues. So let's get started. Strategies for permanent residence. Now, one of the things about the strategies for permanent residence is whether you're E3 or whether you're anyone else, you have to really avoid some pitfalls that are implicit in the process. And so we want to make sure that we provide for you all the information that you need to have a successful PERM. And the permanent residence process really, Vikram Reddy, I will please put your questions in the Q&A instead of the chat. It just makes it easier for me to respond to, and I will get to all those questions about extensions and how it affects your green cards and how it affects your extensions and renewals. I promise I will get to all your questions. And then you have to make sure proactively that at the PERM stage, you are putting all the things together so you have a successful I-140 and successful 485. And then as you're going through this, what are some strategies to think about with dual intent and extensions? So E3 regulations generally, extensions can be granted up to 2 years. It's granted indefinitely up to 2 years. Indefinitely means there is no number of extensions that you can get, like H-1B or with L, where they have a certain validity. H-1Bs, you can only have it up to 6 years. L's either 7 or 5, depending on the type of L. So with E3s, there's no restriction that way. Now, it is true that E3 shall maintain an intention to depart the United States upon the expiration of their E3 status. However, this has been solidified not only in the regulations, but in numerous memos, that the E3 extensions may not be denied solely on the approval of a labor certification or an approved immigrant visa application. The other thing is E3 can work full-time or part-time. And if an E3 applicant presents more than one valid LCA, the adjudicator can evaluate it on its merits separately. So that's something to talk about when we talk about concurrent E3s. So first, before we even get to the permanent residence process, let's talk about priority dates. Priority dates are a pretty significant part of the permanent residence process. Priority dates dictates whether you can either adjust or cancel a process and actually get the benefit of your permanent residence process. And so the priority date, for the most part, is the date that the perm or immigrant petition was filed. That's what determines where your place is in line. And priority date is country of birth, not citizenship. So even if you are an Australian citizen, but you were born in another country like India or other countries, the country of birth would prevail. Considerations are typically, should I do EB2 or EB3? Maybe you can do both. There's cross-chargeability issues, which means if your spouse was born in a country other than India or China that are oversubscribed, you can sometimes leverage their citizenship for your permanent residence application. And then finally, EB3 retention. Once you get an approved I-140 petition, that priority date vests with you. Even if you file another application, even if the employer revokes it, that priority date, once the I-140 is approved, vests with you. So that's pretty critical to know. And just so we understand, this is a copy of the Visa Bulletin. Visa Bulletin is issued by the Department of State every month. And because I'm going to guess a lot of you are from India, EB2 and EB3, as you can see, is October 2009 and March 22nd, 2010. Now, this is the final date. So the Visa Bulletin is either, final action dates or dates for filing. The Department of State publishes the priority dates every month, but it is the USCIS that tells us whether they're going to accept dates, final dates, or dates for filing. And this is an example of final dates. Now, the other thing I want to tell you is there is a ton of legislation that's in the pipeline to remove backlogs, which means this is the perfect time for you to get started with your permanent residence process. Because if you get started with this process and the legislation is approved, then you will be in queue because it's going to, the backlogs will come again, but at least you'll have the ability to adjust status. Now, the permanent residence process is a three-step process. Stage one is with the Department of Labor. You have to file a prevailing wage determination, then you have to go through recruitment, and then there has to be a notice of filing. If there's any, particular types of resumes that are deemed interviewable, then the employer has to interview them. So whatever job description you come up with here is going to be really critical going forward. And if you are in a professional position, which you would be, because otherwise you wouldn't be eligible for the E3, you have to do 3 other types of recruitment. And we help the employers identify that. After, now it's just important to note the prevailing wage determination is taking 8 to 9 weeks. So you can start most of the process without waiting for the prevailing wage determination. Sometimes we'll file 2 job descriptions just because we're not sure where the prevailing wage determination will fall. So that's just a tip from me to you. Then secondly, second stage is you file with the USCIS. Once your perm is approved, and it's taking about 6 months from the date of filing to get those approved, you're ready to file your I-140 with the USCIS. the I-140 can be premiumed. And at the I-140 stage, they want to make sure that the job qualifications that were outlined in the job description, that the employee had them before they joined their employer. That's important to note. The other thing is they want to make sure that the employer has the ability to pay. And so this is what you will do at stage 2 for the I-140 stage. Then when there's an available visa number, that means when your numbers are current. So remember when we looked at the visa bulletin, let's look back. You see that there are dates, and on the left-hand side, or maybe your right hand, it says employment-based first preference, second preference, and third preference. Those are the various employment-based categories, and we'll go over that in just a second. And you see that there are countries up top, all chargeable except those listed: China, Honduras, India, Mexico, Philippines, and Vietnam. So for some countries, especially China and India, you see a lot of dates that are there. That means those people who have filed a perm on that date or before are eligible to adjust status. That date that's listed on there is your priority date. So at that point, you would be able to file your I-485 or consular process. Now, as I stated, it's important to remember that there are some creative, innovative things that you can do when you're going through this process. But you want to make sure at the forefront, and I see this all the time with a lot of people that, and Purushottam, if you could just put your question in the Q&A, I'll get to that in just a second. You want to make sure that you address all these issues when you're starting the process. And what do I mean by that? Exactly. Education, experience, and ability to pay. Now, there's some considerations with strategy. Evidence of ability to pay. When the employer files a perm, there is going to be a salary listed on the perm. And the employer has to prove that they have the ability to pay the salary from the date the perm was filed up to the green card. But in reality, the only time you really submit evidence of that is when you file your I-140. And there are different ways that the employer can prove ability to pay. One is by their net income is greater than whatever the salary stated on the perm. Number two, if they have been paying you. So if the employer's been paying you, let's say the proffered wage is $60,000 and the employer's been paying you $60,000, even if their net income is negative, they've demonstrated ability to pay. Isn't that great? So that's usually the best way in which, and I try to make sure that when we're filing the perm and we're putting together, trying to get the prevailing wage, that we try to align it to what the employee is already being paid. Education and experience. So a lot of times people want to beef up their qualifications because they think that's the only way they can get it approved. That's not necessarily true. But you want to make sure that whatever education and experience that you are outlining for that position, that you have that before you gain the job. Another thing is, if you were trying to say that you have a master's degree, but your master's degree is not in the United States, you want to make sure you get a credentials evaluation for that, to make sure that your master's is from an accredited institution, or a few of your masters. So there are ways in which you can do this. And one thing I want to point out is, even though for the E-3 and for the H-1B, if you want to prove that you've got the equivalent of a U.S. bachelor's degree, you can use experience. 3 years of experience is equivalent to 1 year degree. You can't do that in the green card stage. You can use multiple degrees to show you're equivalent to a particular degree, but you can't use experience. Why? Don't ask me. It just makes no sense to me. But a lot of things in the USCIS regulations make no sense to me. So, but that's what the regs are. So one of the key and I think most critical parts of your perm process is the job description. Like I said, most people think that complex duties are good, but that may increase the wage. And if it increases the wage, what happens? You may have a problem with ability to pay. Another thing is you've got to make sure the the Department of Labor has very specific job titles. These job titles are dated. They came out in the late 1990s at a time where there was no such thing as AI or smart appliances or, a lot of things that we have now. So unfortunately, you're stuck with the outdated job descriptions. So if you don't kind of massage the existing job descriptions to what you're currently doing, what happens is if DOL determines that it's 2 job descriptions that you have put in place, they'll audit you. So you don't want to do that. You don't want to unnecessarily, puff up your qualifications. Supervisory experience that's required for the job will increase wages. So what you want to do is initially get the general idea of which classification within DOL that you fit into. You want to look at the online wage classifications to see which level you'd most likely fall into. And you want to make sure you're not mixing up, different types of job titles and job duties so that you don't have problems down the road. Now, the permanent residents, there are 4 different wage levels. And this is important, like I said, to think about up front. It is geographic specific, it's skill set, education, experience, and required supervision. So you've got the 4 levels. And so when you're drafting your job description, you want to do that in a way in which it can fall under a level that's most closely aligned with what you're doing and what your current salary is. So once you get the PWD, it's valid for 90 days. So recruitment activities should be completed before the validity of the PWD. So job descriptions, remember this is for prospective employment. So this is not just for what you're currently doing now. I think the backlog is going to be addressed, but back in the day when people would have to wait 10 years, you kind of wanted to think about where you're going to be, not just where you are. In some instances, if there is a vast difference between the experience you gained at your employer and the type of work that you're doing now, there's got to be a 50% difference. You may be able to use experience you gained at your employer. So that's something to think about. We talked about this, about the complex duties, increasing the wage. And when you file your I-140, you have to submit evidence that whatever special skills or experience that you stated in the perm, that you've got experience letters as evidence to back that up. And they have to be pretty detailed. So here's an example of software developer. So as you can see on the online wage survey, it gives us some roadmap that we can work with. You've got what the job description is. So you want to stick closely to that. You have what the wages are for the 4 different levels. So you want to stick closely to those 4 different wage levels as you're drafting your job description. Now the SVP, each job title has an SVP. The SVP determines whether you can file EB2 or EB3. And how it works is a job requiring a bachelor's degree and 2 years of experience will have an SVP of 4, making the SVP level a level 7 job. So a master's degree will be counted on the basis that it's required to earn the degree plus the 2 years of bachelor's. So bachelor's degree is counted as 2 years. Master's degree is counted as whatever the years is. Let's say it's 2. So a job requiring a master's degree that can be earned in 2 years will have an SVP of 4 years. So making the SVP level. So, and why I say 7 is, here we go. I think this will tell you. The SVP level that's outlined by the DOL, as you can see, it tells us what exactly the education and experience can be. So the SVP for 7 is over 2 years and including 4 years. So from 2 to 4 years. So if you're going to require a master's degree, you can't require any experience with that position if it's an SVP 7 position. And the reason is, if you go over the requirement of the SVP level, you're going to get audited and it's going to delay your process. SVP 8 is over 4 years, including up to 10 years. So those are the perfect EB2 type positions. But even though it's an SVP 8, it doesn't mean that you can't file it for an EB3. So EB3 is anything with any position that requires a bachelor's degree or greater. EB2 is where the minimum requirement is, a master's degree or a bachelor's plus 5 years. So just because the EB3 baseline is a bachelor's degree doesn't mean that a master's degree can't qualify for that. Okay, it's the minimum requirement, not the maximum requirement. That's important to remember when we talk about strategies. So what you want is you've got to look at the various job zones. So job zones will tell you whether, how much experience and is required for the job. So job zone 4 and job zone 5 are usually better for EB3 and EB2. So here's an example. Let me see, did I do? Okay, here's an example of EB3. A job zone level 3, SVP level 6 through 7. Now, if you structure it so you say a bachelor's degree plus 4 years of experience. Remember, a bachelor's degree, bachelor's degree, but two years of experience. So 2 plus 2 equals 4, you're okay. That's a typo. A master's degree plus 2 years of experience. Remember, you have to count the bachelor's 2 years plus the master's 2 years. So that's 4 years. And if you have 2 years of experience, that's 6 years. And that would exceed 4 years, which is the maximum you can require for an SVP of 6 to 7. SVP EB2, job zones are usually 4 to 5. And it's usually the SVP level of 7 to 8 years, 7 to 8. Computer architects, computer managers, systems analysts, they all fall under, SVP of 8. So those really work with filing these types of petitions. And if you structure it carefully, you can file with one perm, you can file an EB2 and an EB3 at the same time. And you can do it premium processing. So you'll have an EB2 I-140 approved and an EB3 I-140 approved. And if the visa bulletin fluctuates, like for any of you that have been paying attention, in October, EB3 advanced. So those people that had an EB3 I-140 were able to use that to file their adjustment of status. But because a lot of people filed EB3 in October, EB3s may retrogress, may go back. So if you have an EB2, you just have to interfile, and you'd still be able to leverage that without having going through the process all over again. So that is a tip that you can use to go forward. Now, strategies for E3 extensions. I know everyone is worried about the fact that E3 is not implicitly a dual intent visa. We've done a lot of E3s. I've gotten a lot of green cards for E3s, and there is a provision within the regulations that state that an extension cannot be denied just because this individual has got a labor cert or they've got an approved I-140 petition. So even though it's not explicit dual intent, it's implied. And when you file an extension, you can file your extension here in the US, which may be the better process to move forward. And you have to know that when you file an extension, you have 240 days in which you can continue working on the E3 while your extension is pending. Another thing you can do for your I-140 is you can ask for consular processing. If you ask for consular processing, then that means instead of adjusting status in the US, you can consular process your green card, which would mean that you would be adhering to returning to your home country after the expiration of the E3. It doesn't mean that you will return to your home country indefinitely. It just means at the end of the E3. That's one thing. And another thing is, even if you opt to file as consular processing for your I-140, you can always change your mind and adjust status in the US. And we have found that even with people with permanent residence application pending, that they don't have an issue getting their E3 extension. The denials that we've seen are usually because of wages and other things, but not related to issues about dual intent. And if it is, it's because the individual didn't, show the consular officer. Very few extensions that have happened in the US have been denied for that reason. It is more on a consular level, just because the consular officer is not aware. So what we do is we make sure our clients take in a letter from me that states, you cannot deny this person on the basis of having an approved I-140. And the statistics that we do have in 2017, I think there were over 5,000 E3s that were issued that year, and there were only 600 denials out of the 5,000. The vast majority of those denials had to do with wage and the job title, that it was not a professional position. So that was the number one reason why the 10% of the denials took place. A lot of other people have asked me whether they can have multiple E3s with employer A and employer B. The FAM, as I showed you at the beginning, clearly outlines that it is permissible. But you have to make sure that when you submit it, that you outline what percentage of the time that you're going to spend with each employer. If you're going to say 40 hours with employer A, 40 hours with employer B, well, that's not going to cut it. They're not going to believe that you can do 40 hours with two employers. But you can get a part-time E3. So you would do one with full-time, and then you could do a part-time concurrent E3. So please join us for our webinars. We have them every Wednesday. Join us on social media if you can. For those of you who have not signed up for our Telegram group, we've got a Telegram group that's specifically targeted towards E3s. And like I said, there is going to be a lot of new rules coming out. And so this is the time that you have to be engaged and make sure that you're getting the right information so you can go forward and be successful in your immigration journey. Other ways to connect to us are, on social media. I'd love to hear from you. I mean, when I interact with everyone, I know what issues are troubling people, and we can make sure that we target our content to the things that are most critical to you. And like I said, we have a lot of great information on our webinars, so please make sure you tune into our webinars and check those out, and subscribe, share with your friends, comment. We'd love to hear from you. And if there's any specific questions, of course, I'm going to do some Q&A next. But if there's anything specific that you would like us to know, sometimes I need additional information, email us at info@challalaw.com. People always ask me, Madam, can I have your direct email? Of course you can. It's lchalla@challalaw.com. But info@challalaw.com goes to 4 different people in my firm. So then you are assured that it will get our attention and my attention, and we can respond to it. So this is the best mechanism that you can use to contact us. So let's get started with the Q&A. I'm going to start pulling up the questions, and I'm going to start from the very top. This question is from Sunny. Sunny says, if we find an employer who can place me outside the United States for 1 year, can I apply for an EB1 category? Well, it's not just that they would have to do that as an executive or manager. So it's not just that you're working for a multinational company, but you'd have to be working for a multinational company in the capacity of an executive or manager, not only overseas, but in the United States. But if you do that, yes, you can file for EB1. Mr. Kalagata, hi Lakshmi, I have a question about a change of employer. If I have a visa until July with employer A, can I get an LCA for employer B and go to the border and come back without a consular appointment? Is that a valid change? You can also just file in the United States for change of employment. Portability doesn't directly, but there are some rules with relation to changing employers. So, you could do that here in the US. Going to the border right now because of COVID, it's kind of, I know Canada has got a lot of restrictions. We're going to be having here in the United States, if you travel abroad, that you've got to home seclude for 2 weeks. So that may be problematic. Can you please advise on how to deal with the recent requirement that the LCA must be filed by the end client? There is no requirement that the LCA has to be filed by the end client. The end client cannot file the LCA, Raju, so that is not an issue. You don't have to file the LCA by the end client. The end client has to provide a letter, and that may be, some of those issues may be changing within the Biden rules, but there's a federal court case that said as long as the employer can show that the employer has anticipated work and not speculative, then, but an employer has never been required to file an LCA. So that's not a problem. Mehendi, I've been offered a full-time job in the US and should very soon be in American soil. Congratulations. As I've asked the HR to apply through an E3 visa, I wonder if it would be possible for me to switch from E3 to L1B while I'm in America, for the reason that I'll be processing time for L1B may take between 2 to 6 months, while the E3 would only be 10 days. Another reason of mine regarding the E3 is how the applicant could stay in the US after applying for the green card, because once you've applied for the green card, your E3 will expire. No, your E3 will not expire. Okay, let me answer this in 2 instances. You can file for you can change status to an L1B within 3 years from your date of entry. If it's more than 3 years and since you've entered the United States, then you wouldn't be able to change to an L1B. The reason is, for Ls, you have to show that you've worked overseas for 1 year out of a 3-year window. So it can be 1 year out of the 3-year window from the date of entry. So you just want to make sure that that date doesn't expire. Number 2, as I stated, we've had E3s get green cards all the time, and that is not a problem. It is there in the FAM, it is there in the regulations, it is there in the memo. Hi, Challa. Hi, Ganesh. I'm glad you joined us today. My PWD launch is 8/26/20. I have not received, per your present, it takes 8 weeks. Yeah, you're right. But at the end of the Trump administration, they were trying to change the PWD requirements and increase the wages. So they did that, and it was effective immediately. Then DOL had to change all their wages and kind of comport with that. Then a federal court stopped it and enjoined it. So then DOL had to change back to the older way they've done wages. So that's why you have the delay at this time. If we apply for GC in February, stage 1, and the stage 2 process timeline, can we get the rough estimate for EB2? I understand stage 3 comes per priority date. What are the options of mentioning this in the DES 160 when we renew this E3? You can file for the E3 in the US, or you can file for it at the consulate, either way. And you file for it, and then you submit the memo that says that E3s cannot be denied an extension just because they have a labor certification or they have an I-140 approved. Another thing you can do, as I pointed out, is you can state on your I-140 that you're going to consular process. You can change your mind later, but you can state on the I-140 you're going to consular process, which means there is no reason why they can deny it, even if they don't, understand what they're able to do. So on the I-140, you indicate whether you're going to adjust status in the US and consular process your green card. It's not written in stone. Just because you state it on there doesn't mean that's what you have to do. But by doing that, when you go for your interview, you can say, hey, the regulations state at the end of my E3, I just have to come back. I have to show an intent to come back. My I-140 is approved, but it's for consular processing, which means I am coming back. So that is, kind of an innovative way in which you can get through that without any problem. My job role has changed since my I-140 got approved and moved to a different company. Does this impact my green card process? Yes, Shiva, it does. I mean, you have to go through the I-140. I mean, you have to go through the permanent residence process again. But the good news is your priority date vests with you. So even if your job title's changed, even if you changed with a different employer, you can leverage your previous approved I-140, even though you have to go through the process again. So, but I would jump on that as soon as you possibly can. And if there's any way we can help, we're happy to do that. But, and I'll try to emphasize that at the end to kind of tell you why. Is premium process available to transfer EB3 to a different employer within the US? They were supposed to, like years ago, and I would have to, I believe it is, but let me check and make sure. There are a couple of things that they're changing with the premium process, but and some of the things that they wanted to do, the mechanism didn't roll out while they were changing. But Mr. Kalagara, if you can email me at info@challalaw.com, I'll give you a definitive answer. Shiva, what happens if at all you go out of the country once the I-140 is approved and come back after a year or so? Would the process of green card still be active? Yeah. I mean, it depends on whether there was an available visa number. So if you're going to do that, I would definitely do consular processing. And yes, you can do that. You can go out and stay overseas if you like and process your green card abroad. I filed my case through my employer immigration attorney who's not aware much about E3. In this case, can I use your service if I come across any issues? Absolutely, Ganesh. We're always here to help. And that is why we started the E3 groups, because when somebody asked me, why don't you do an E3 group about permanent residency? I said, why? That's not a difficult thing. That's pretty standard. It's pretty straightforward. And then suddenly I started seeing all these people thinking that they can't get their green card because they have an E3. And that's why I started this Telegram group. So yes, and I find that a lot of attorneys have not had a lot of experience with E3s, which could be problematic, but we're always happy to assist. Hi, so we can have an E3, one for 40 hours and the other for 20 hours. That's exactly what the FAM says. Yes, Vikram, you can. You can have two, and that's exactly how I would do it, a 40-hour and a 20-hour, because it's got to seem reasonable. My visa extensions are processed by my company attorney, and they always say E3s are not eligible for green cards. If you want one, I have to change my category to H-1B. Purushottam, please have them. Let's set up a call and talk to them. I can show them, tremendous regulatory guidance. It's not me saying this. This is the USCIS saying this. This is the Department of State saying this. This is the USCIS director saying this. And just because your attorney, the company attorney, doesn't know much about E3s, they're saying that they're not eligible, but they are. And I would be happy at no charge to talk to your employer, even if they don't want to use me, right? Even if they want to use their existing attorney, I'm happy to talk to them to educate them on the fact that that is incorrect. Satish Yada, do you think the new regulations for H-1B is better or EB-3 is better? Do you think the H-1B is always better for our situation? Hi, Satish. I don't know if one is necessarily better than the other. I think each one has its challenges. It's always good to have, if, it just gives you another, especially because H-1Bs are subject to the cap, you might as well apply for it just to give you another safety net in case there's any crazy changes to the E3 regulations. But things for all categories are going to get better. They're not going to get worse. So I applied for my E3 extension. If I have not received my E3 extension within 240 days, what is my status? Ganesh, that's a really good question. So I talked about the 240-day rule. The 240-day rule is not a USCIS rule. It is a rule that's outlined in the I-9 regulations. The I-9 is where you prove that to your employer that you've got authorization to work in the United States. So if you remember your I-9, your employer probably I-9s you. And so because your employer I-9s you, then it means that you have to show some proof when you're filing an extension as to whether you've got authorization to work. And so with the initially E3s weren't on that list. They changed that, I think I would have to say either in 2016 or 2017. And so what has happened is they've stated that as long as you file prior to the expiration, for 240 days, you can work with a copy of the receipt notice. Your status, as long as you file prior to the expiration, is good until it's adjudicated, right? So it doesn't impact your status, Ganesh, at all, even if you're beyond the 240 days. You just can't work beyond the 240 days. I hope that made sense. Satish, can we apply for EB-1 even though I am in a manager role in the US? Yes. And sometimes it's, there are two types of managers, a regular manager, or there's something called a functional manager, where you are managing a particular function in the US. But either one of those categories would, L1 categories would be eligible for an EB-1. Zoheb, hello everyone. Question, what if we do adjustment of status on E3, apply for a green card I-140? Can we still extend our E3 if it takes more than 10 years? Because what I heard is if you apply for immigration, the intent will be to immigrate to the US and it'll be hard to contain afterwards. The regulations don't state that, Zoheb. And like I said, I don't think there's going to be a backlog going forward. I think the Biden administration and I think Congress is going to pass immigration reform, and that would be the best way to do that. But somebody asked for a link on our Telegram. I'm going to give that to you just 1 second. So what I'm stating is in and of itself, it should not preclude you from being able to obtain an extension. People have done it and they haven't had any issues. Now, another way in which you can structure your I-140, especially because there's a backlog and you're going to be waiting, is to file it as consular processing. I just sent everyone a link to the Telegram. Sorry. So please share that with your friends if you can. And join us on the Telegram link, especially now because we're going to be having a lot of really critical, lots of information that is going to be changing. So you want to make sure you did. So Ganesh, I just in chat, I just sent out the Telegram link. So I hope you join us. Shiva, do you have any case so far? Yes, I've had several, Shiva. He asks, have you had any cases where people gotten approved for an E-3 visa holder? Yes, I have. There was a multinational company that had a lot of Australian, so I did a lot of E3s in my day. Zoheb has another question. What to do if the adjustment, can we extend it? Okay, I've already answered this, Zoheb. Very good. Raju, I heard that H-1Bs are not lotteried this year. They're going to be picked up based on wage levels. That is correct. That's what the Trump administration wanted to do, but that's not how it's going to play out. I'm pretty sure it's going to be lotteried again. I think there's going to be the registration process will be in place, but I don't think the Biden administration is going to make selection based on wage levels. If the I-485 is filed and in pending status, and I want to move to another company, what can I do? That's a very good question, Vikram. So the way the regulations work is after you filed your I-485, your adjustment, you are able to port to another employer if 3 conditions are met. The I-140, underlying I-140 must be approved. Number 2, the I-485 has to be pending for 180 days from the receipt notice of your I-485. And the third prong is you have to work in same and similar employment. And it's a very broad description of what same and similar is. So, there's no clear definition, but it's very broad. Right now, the Trump administration tried to narrow it. I'm pretty certain that the Biden administration is going to bring it back to what it was previously. So Vikram, those 3 conditions are met, you can change to another employer. Okay, another question. Can an E-3 visa holder work on the receipt notice when applied for a new visa onshore for change of employer? The portability of H-1Bs does not apply to E-3 visa holders. So I'm afraid not. Prasad has a question. Hi, Lakshmi. Hi, Prasad. Thanks for making time for this session. If I apply for a green card in a family category through my wife's sibling who's a U.S. citizen, okay. Prasad, that takes 12 years. Buddy, if you can get somebody to apply for an employment-based, you would have a much better chance of getting a green card through that than you would through the family base. So that is what I would suggest for you. And I wanted to tell you all 2 things. Number one, let me see if I can find, I don't think I have it. Okay. I am, like I said, I'm part of API 100. So I'm really involved with the changes that are going to be taking place on the immigration realm with this current administration. I am also, one of the Challa law interns works for one of the key legislators that is spearheading this whole change. And I was just talking to her the other day. So we have the inside track. If you want to know what's going to happen, before it hits the news, then make sure you join us on our weekly webinars, join our Telegram group, connect with us on our various types of medium, and we will make sure that we're able to help you. There is a question, I think this is probably going to be the last one. Marnie has a question. Are there restrictions on the number of EB1 applications based on country of birth? Also, EB1, do I have to be outside? Okay. So Marnie, here's Marnie asked about the EB1 category. EB1 can be multinational manager or executive. It can be extraordinary ability. It can be outstanding researchers or professors. If it's multinational manager or executive, you have to work in the overseas entity and the US entity. They'd like to see you working in an executive capacity. And each one of those categories, EB1, EB2, EB3, they all have some, they're all allocated per country. And so some of that is going to be addressed because there are a number of bills, and even President Biden's immigration plan included eliminating with per country quotas so that everyone would be current to a certain degree. So that may not be an issue going down the road, but EB1 certainly has less of a backlog than the other categories. So it's probably a better category to apply for because it usually doesn't have much of a backlog like EB2 and EB3. And I know I went over a lot of things today, and I know it could be complicated. We have done a lot of E3s to green cards, and I've never found that it has been a particular problem. We're going to be having, this session was specifically targeted for the EB3 individuals, but we have our general immigration webinar every Wednesday. And I can, send you a link to that as well. So please join us even for those webinars, and we would be, oh gosh, okay. We would be happy to, I don't know if I can get the link for that. Let me see. I'm trying to find the link for my Zoom webinar, but if I don't have it, email me at info@challalaw.com, and I'll be happy to send it to you. And I'll post it if you're part of the Telegram group. I'll make sure I post it on there. And this is the time. I'm telling you that the backlog is going to be eliminated within a year. So if you don't get started with your permanent residence now, you're going to really regret it, because this opportunity doesn't come up again and again. And whatever they do for the backlogs is not going to remain permanent, which means at some point they're going to backlog again. So if I were you, I would go ahead and get started. If your employer does not understand how E3s can process green cards, I'm happy to talk to them. Thank you for giving me your time on Saturday. If you have any additional questions, email us at, and I'll put it in here, info@challalaw.com. Join our, Wednesday Zoom meetings. And let me see if I can put I'm gonna try it one more time to see if I can put a link into that so that you all can join. I'm trying to find trying to join get the link for you. 1 second. Here we go. I've got the link. Sorry, guys. I usually have someone that's doing this for me. Here's our webinar link. There you go. Oh, thank you, Challa. So that's great. So there, there's our webinar link. And I think there's 2 more questions. I'll answer those. I wish you had this webinar 10 years ago. Anonymous attendee. Zoom just kind of really took birth over the past year. I think COVID kind of drove this, but you were right. I wish there somebody had a webinar like this when I started out and I was going through my immigration problems. That's why I got into this. Even though I grew up in the United States, my parents took me home back to India for more than a year as a permanent resident, and I couldn't come back. So I had to go through the process all over again. And I know how difficult it is. That's why I'm doing this. And yes, I wish there was a Zoom meeting back then as well. Lakshmi, I had another question as well. If everything goes well for the E-3 visa holder, when he or she apply for a green card, how long would it take? Just an estimation. Well, the green card process, you can usually, assuming, there's no additional backlogs with the prevailing wage and other things. Once you file the perm, it's taking 6 months. I would give it about a year, and anywhere from 12 to 14 months, you should be completed with the process. So thank you again. Happy Saturday. Have a great Sunday. Relax, think about what we said. And if you've got any questions, email us. We'll be happy to help you out. But go forward, and even if it's not with us, with somebody else. I've gone through this process myself. It's very stressful. So I've been committed to make sure that whatever we can do, we can help people out along the way. So thank you, and have a great Saturday. Thank you, Satish. Take care. Bye-bye.